I will go ahead and call the first case. This is Griffin versus Trumbull Insurance Company. This is a 15-minute mini oral argument on the application. Mr. Hicks, that means you can try and reserve some of that time, but we ask you to do that on your own. And you may proceed if you're ready.
Thank you. May it please the court, Steve Hicks on behalf of the plaintiff appellant, Willie Griffin. I will try to reserve 2 minutes for rebuttal, and I will try to keep track of that time. The court has asked 3 questions in requesting supplemental briefing in this case on the application. Generally, those questions relate, first of all, to the liability of a lower priority insurer in paying benefits. Second question deals with the PIP claimant's responsibility in identifying a higher priority PIP insurer. And then third question basically is an application of our answers to the first 2 questions to the uncontested facts in this case. I'd like to make 2 points, and then I'll be happy to answer questions. 2 points that I think are germane to the first 2 questions. I will also address the diligence issue, but I anticipate there'll be questions on that. So I'd like to open it up to question after I make these first 2 points. First of all, 6 months ago, this court decided a case called Esurance versus Michigan Assigned Claims Plan. And I almost feel that this is a companion case to that decision. And the reason I say that is not because the issues were the same. The issue in Esurance was equitable subrogation, but the court's underlying rationale for reaching the decision that it did, which was basically that Esurance, having paid benefits to the PIP insured, was entitled to pursue equitable subrogation. The rationale the court used was that that's the logic of the No-Fault Act. Justice Zahra, in his the majority opinion, said, and I think this is a good summary of what the No-Fault Act is, he called it the No-Fault Act's pay promptly, litigate later logic, which I think is exactly right. And in this case, we sort of have the predicate to the equitable subrogation question. This court has affirmed the right to pursue equitable subrogation for insurers, but underlying that was the fact that Esurance in that case did what Trumbull did not do in this case, which is to pay benefits promptly. So I think it's important to recognize that case because it relies on the very same cases that I've cited to say that the lower priority PIP insurer does have a duty, does have a responsibility to pay PIP benefits. And that's because the No-Fault Act basically has those 2 concepts, which are PIP benefits need to be paid. They need to be paid promptly. And litigation is not something that we want to make insureds do, that they have to pursue litigation simply to get their PIP benefits paid. So I think that's an important start, and I think it's responsive to the first question in this case. The second point I want to make before opening up to questioning is simply to say, and this is more responsive to the second question, is that it's important to understand in this case, we're talking about an insured that paid premiums for PIP protection. What is PIP? It's personal protection insurance. I know the acronym flips, but it actually is personal protection insurance. Griffin paid a premium for that. He wanted to be protected from his economic losses. That's not what he got in this case, even though he paid those premiums, because Trumbull did not step up to the plate like Esurance did and pay those benefits. He's never been paid any benefits. We're now 5 years post-accident, no recovery, and yet he paid a premium for that. So having made those 2 points with regard to the first 2 questions that this court has asked, and I think they're germane to our discussion of those questions, I'd be happy to dive into the questions that the court has asked about the PIP claimant's responsibility and the diligence required of a PIP claimant. But I think I'd pause at this moment because I know that Chief Justice McCormack often asks the judges if they have questions. So I'll take a pause at this moment. I anticipate some of the questions may go to that anyway.
Yeah, thank you, counsel. Let's do that. I'm going to start with Justice Zahra.
Thanks. Well, I guess a pretty basic question would be, are there any statutory textual clues that would support the conclusion that a lower priority insurer can be held liable for PIP benefits under the No-Fault Act if the higher priority insurer was identifiable but not timely notified?
The statutory clues, of course, are very limited here. I mean, all the No-Fault Act says is that the the insured, the claimant, I should say, shall make the claim in the order of priorities. And your question presumes that and I don't think it's the case here, and the court probably recognizes this, that in this case, the higher priority insurer was not identifiable. So your question presumes that. But to answer your question directly on the statutory clues, they're very limited in terms of what the court says. And our position has been that because they're limited, the insurer's duty is pretty limited as well. And the emphasis of the No-Fault Act, as you said in your majority opinion in insurance, is that benefits must be paid and that the insured shouldn't have to go to litigation. That's the reason we adopted the PIP. Now, the defense, Trumbull in this case, reads a lot into that shall word in the No-Fault Act. Shall claim in the order of priorities to them means file a lawsuit, subpoena witnesses. It's a whole host of things that they read into that shall. I would say that there's really no support for that. And hopefully that's responsive to the question that you asked.
It is. Thank you very much.
Justice Viviano.
Yes, thank you, counsel. I'm sure you're going to get to this, but I guess I'll just give you the opportunity to do so. Even if the statute requires diligence, what facts, I guess, are you relying on to show that your client was diligent in light of the fact that apparently the investigation that was done here never inquired into the employer, even though there appear to have been some significant clues that the truck was driven. It was a commercial vehicle.
Sure, I'd be happy to respond to that. First of all, a couple factual points. There really were limited clues here because of the way the accident report was filled out. The accident report identifies the driver, but it fails to provide a VIN number for the vehicle, which would be the easiest way to search this vehicle and find out who owned it. And it does not provide the insurance information for that vehicle. Now, sometimes insurance information is not accurate, even if you have it on there, but the VIN is really the key component. So the only thing factually that was available in this case to both Griffin and to Trumbull in their investigation was the truck driver. He really was the linchpin on this case because factually that's the way the accident report was filled out. So both Griffin and Trumbull, focused on Gonzalez because the truck driver, because he was the only way to get information about this and confirm that it was a commercial truck. With just his name on the accident report as a witness, you have every reason to believe it might be his truck that he's driving around.
Just to be clear, he's not driving like a pickup truck, right? I mean,
No.
I don't know exactly what this is, but stake bed tandem axle trailer carrying a steamroller doesn't sound like something some people do in their spare time, right?
Now, I think that's a fair point. I mean, it's a big truck. I don't have one. I don't plan on getting.
Me neither. I don't even have a pickup truck. But.
So that clue is there. But in terms of the diligence exercised by.
What about one other fact that I want you to talk about is your client observed logos, I guess, on the truck as well. There's testimony to that effect.
I don't recall that specifically, but I think that may be correct, and that there was some indication that there was a company associated with it. That might have come from the witness who was identified at the scene, the one that said that the truck swerved into the motorcyclist into my client's lane. So that might.
Why didn't the investigation include an investigation into where this individual worked?
Because no one could get to him to ask him where he worked. Both sides tried the same approaches. Griffin's counsel sent a letter to Gonzalez, no response. Trumbull also sent multiple letters to Gonzalez, no response. Trumbull actually got him on the phone. He deferred, hung up. He had various responses to that approach. Trumbull, through their special investigations unit that they tasked with trying to find the prior priority insurer, they actually went out to his house multiple times, couldn't get him. couldn't find him. It was only by happenstance later when the lawsuit's filed that they actually do get him. But the point I'd like to make is that Griffin's attorney did the same things that Trumbull tried to do. They tried to get a hold of Gonzalez. He sent him a letter. He also put Gonzalez through the system because maybe Gonzalez owned the truck and was running some sort of commercial operation under a DBA. Trumbull also did that as part of their investigation. Of course, it failed. They
Did
didn't
they ever determine who owned the truck?
No, they did, Your Honor. What's unusual about this case and why it's different from Frierson and some of the other cases that have come before it, what's unusual is that once the lawsuit was filed by Trumbull and Gonzalez was subpoenaed, he called up Trumbull's counsel and said, do I have to do this, come for a dep, whatever, and agreed to do that. And when he came to the dep, he did testify. That's why Trumbull's position is, oh, you should have filed the lawsuit way earlier and gotten that subpoena power. Of course, that's something they could have done as well. You can always file a deck action. They could have paid benefits. And also when they say to Griffin and his attorney, oh, you should have done that. The fact is Trumbull never told Griffin or his attorney that, hey, we're not paying. So go, sue us if you want, if you have to, but that's your recourse. All they ever told him was, hey, we're investigating. And then they did their investigation, closed their investigation because they couldn't find him. That's what their investigator said. Did they tell Griffin? No, they didn't. And yet they say Griffin should have sued. He did sue, and he sued before the 1-year back rule was going to kick in, and he sued everybody he could identify. So hopefully that's responsive to the questions that you've asked.
All right. Thank you, counsel.
Thank you.
Justice Bernstein.
Good morning, counsel. Welcome. I don't have any questions at this time. Thank you.
Justice Clement.
No questions. Thank you.
Justice Cavanagh.
I do. Good morning, Mr. Hicks.
Morning.
So is there an argument to be made? And if there is, has it been made? Is that up for us to decide that Trumbull is stopped from asserting that a higher priority was identifiable based on their own conduct in conducting an extensive investigation and closing their own file, having determined presumably themselves that that a higher priority wasn't identifiable. More of an estoppel, I guess it's more of a factual argument in this particular case. Was that made? Or I guess is it relevant if it's not to what we're dealing with here?
On the one hand, it was not an argument that was made. When it was argued below, counsel's position was that they had used diligence to try to find it. And then ultimately, when it was discovered that Trumbull had investigated as well and failed, it was brought to the court's attention that even if we'd done everything they did, we wouldn't have been able to get this driver to talk. The judge was not impressed by that and found that Griffin failed to use reasonable diligence, where even though Trumbull also failed to identify coverage. So the answer to your question is, with regard to equitable estoppel, that was not briefed below. That has been a consideration in other cases, such as the unpublished Levander case, which was remanded to the trial court to first assess the identifiable question, but then even if it was identifiable, then look at issues of equitable estoppel or mend the hold. So it has come up in other cases, but it was not briefed in this case.
Okay, thank you.
You're welcome.
Justice Welch.
No questions.
Mr. Hicks, you want to reserve that 1 minute and 18 seconds?
Yes, I would like to do that. Thank you.
Okay. Ms. McAllister, Ms. Kingler, I'm not sure if you're splitting argument or if one of you is taking the lead, and if you're splitting, who's going first, so go. You look like you're speaking, but you're muted, Ms. Kingler.
Sorry about that, Your
No
Honor.
problem. No problem.
I will proceed first. The MACP and Trumbull will split the time with 10 minutes to Trumbull and 5 to the MACP.
Perfect. Okay, great.
Your Honors, the first question the court asked is whether a lower priority insurer such as Trumbull can be held liable for personal protection insurance benefits when the higher priority insurer wasn't identified before the 1-year notice period of MCL 500.31451 expired? And the answer to that question is no. The majority in the Court of Appeals in this case relied on the prior Court of Appeals decision in Frierson versus West American Insurance Company to conclude that where a higher priority insurer is identifiable, even if not identified within that 1-year period, then the lower priority insurer cannot be liable. This is the most consistent interpretation consistent with MCL 500.31145, which provides that an injured person shall claim personal protection insurance benefits from insurers in the following order of priority. And I'll substitute the word statutory order of priority in that quote. That mandatory directive requires a claimant to seek no-fault benefits in the statutory order of priority. If there is an identifiable higher priority insurer, then the lower priority insurer can't be identifiable. I think what the plaintiff is suggesting here is a sort of discovery rule that where a higher priority insurer isn't actually identified within the 1-year notice period, then the lower priority insurer becomes liable. But that requires the court to legislate provisions that are not within the No-Fault Act. The legislature hasn't created such a discovery rule, and defendant respectfully submits that it's not the role of this court to do so, as the court stated in DeVillers, or recognized in DeVillers. It's a prerogative of the legislature to set policy and of this court to apply the statute as written. And the statute says the injured person shall claim in the order of priority.
Ms. Kingler, let me interrupt you and see what questions, especially since you're splitting time, I want to get everyone's questions to you.
Sure,
So,
thank you.
yeah, Justice Zahra.
No questions at this time. Thank you.
Justice Viviano.
No questions. Thank you.
Justice Bernstein.
Hey, counsel, good morning. You know my judicial philosophy. I like to keep things simple and I like to make it as applicable to the real world as possible. So I'm just going to ask kind of this question, and I realize the complications that are present here in this fact pattern in this case, but I would like, if you could tell me, what would you have liked the plaintiff to have done?
I think the plaintiff in this case, although the No-Fault Act is intended to discourage litigation, the plaintiff did need to file suit and obtain that subpoena power where they could then depose Gilbert Gonzalez and learn who was his employer and who was its insurer, Your Honor.
Okay, thank you.
Justice Clement.
No questions. Thank you.
Justice Cavanagh.
What was the basis for Trumbull not paying benefits upon receipt of the claim?
Your Honor, Trumbull did not, as plaintiff has pointed out, did not directly communicate with plaintiff, but at that time we would point out that there was an extremely high likelihood that there was a higher priority insurer in existence.
Was it identified at that point?
No, it was not identified.
Was it not identifiable at that point?
It was at the time when Trumbull closed its investigation, perhaps the insurer was not identifiable, but the insurer was identifiable in fact.
So Trumbull had decided at least, what was it, December, 6 months after the accident, at the close of its investigation, that based on its own efforts, there was not a higher priority insurer identifiable. And you did not begin paying benefits at that point, correct?
That is true, Your Honor.
Okay, so I understand that perhaps at best the statute doesn't really give us direction of who's supposed to file suit or who's supposed to be the one to identify or determine, who is identifiable or not. And I get you're saying they should, and they're saying you should, and that. But what do we do with? I mean, there's a fairly significant amount of at a minimum case law authority sort of around this issue, saying that, you know, the purpose of the No Fault Act, as you indicated, is to avoid litigation. In fact, attorneys are obligated to advise clients that they don't even need an attorney to file. So if you don't need an attorney, let alone then you don't need to file suit. An insurer who doesn't pay a claim based on a priority dispute can be held to have unreasonably denied benefits, right, and be subject to attorney fees. So a priority dispute isn't enough to even avoid attorney fees. Doesn't that, if we can't draw something, you know, explicit from the statute of who is supposed to do that, can't we draw the conclusion that if it has to fall on somebody, that it falls on the insurer, given all of those other concerns, really sort of undisputed, I think, policies around and interpretations of the No Fault Act of how this system is supposed to work and who is supposed to be doing what?
Your Honor, thank you, Your Honor. I'd like to very briefly address the priority dispute issue, because in this case, there is not a priority dispute. First of all, the Court of Appeals held there was no priority dispute, and plaintiff has not appealed that determination. Secondly, there's simply no dispute that Harleysville is the higher priority insurer. It's not a case like a question of domicile where there are two insurers that could be higher in priority depending on how that issue is resolved.
Well, I guess maybe it's a timing issue. So I understand that if this determination that Harleysville is a higher priority insurer was made, and based on that, you didn't pay the claim, or you sought to recoup what you did pay to Mr. Griffin from Harleysville based on that determination. But at the point that Trumbull denied their insured payment for a claim, there was no identifiable insured, even by Trumbull's considerable efforts, right? There was no identifiable higher priority.
At that moment in time, no, but that higher priority insurer was identifiable. The statute says that it's the responsibility of the injured person, or it strongly implies the defendant would suggest that if the injured person has to make a claim, then it's their responsibility to determine who is in the order of priority. Then it's their responsibility to determine who is the higher priority insurer. That is not Trumbull's responsibility.
And you're saying that's all implied from the word shall claim from, right?
Regardless
of the fact that the insurer, you know, the structure of the no fault is that you claim from your insurer, your own insurer, unless there's somebody higher in priority, that, you know, the purpose is to you know, avoid litigation and get people compensated for their injuries and for claims. That the word shall suggests that somebody needs to, that the insured is the one who needs to ferret out the higher priority insurer.
I think that's the only clue that the legislature has given us, and that it does imply that it is the insured who must determine the order of priority. Yes.
Okay, so you do not feel that Trumbull had any, despite the fact that no other insurer was identified, or at least identifiable at that point, Trumbull did not have an obligation to pay the claim for the full year that they left it up under investigation?
No, Your Honor, there was no priority dispute there. There was a higher priority insurer, and there was an extreme likelihood that that insurer existed and was identifiable. And in fact, it was identified.
Okay, thank you.
Thank you, Your Honor.
Ms. Klingler, I'm going to give you the opportunity if you want to turn the microphone over to Ms. McAllister. She can answer the questions from the rest of us. I don't know if that's okay. Ms. McAllister, I'm going to let Justice Welch ask you the next question.
Very well. Thank you, Your Honor.
Okay, yeah, great, thanks. I'm just wondering, I think picking up what Justice Bernstein was asking, so is the position of defendants that essentially a plaintiff insured always has to file a lawsuit to basically ensure that insurance companies get a subpoena to find out who is in the higher order of priority? Is that the position today?
I think that this is one that Ms. Klinger and I would answer differently.
Okay.
I suspect she would say yes if you don't know, and I would say no.
Okay.
If you have a situation where you, as a plaintiff, have done an investigation, you have exercised reasonable diligence, which is the usual standard that we apply to any plaintiff when they are coming in, you can then make a claim over to my client, which is the Michigan Assigned Claims Plan. But I think, as I said, Ms. Klinger would probably answer that differently and say that in a situation like this, you should be required to exercise diligence a step further and file a lawsuit claim.
Okay.
And Justice Welch, I didn't mean to cut you off. Did you have another question?
No, that's fine. So
Okay.
I actually, and maybe Ms. Klinger can like quick jump in. Do we know, was there a contractual obligation to investigate the claim here? I know most policies have that, or a lot of policies do. So I was just curious on that fact. You're
on mute again.
Sorry. Your Honor, there is no policy in the record, assuming that our policy includes a duty to investigate the claim. There's no reason to believe that includes a duty to identify a higher priority insurer. I think the rule book is the statute, as this court has held in the past, and the court needs to look at the statute, which again says that the injured person shall claim in the order of priority, and that includes a duty or implies a duty to ascertain the priority.
Okay, thank you.
Now you may continue, Ms. McAllister. You have a couple minutes.
Okay, thank you, Your Honor. As Mr. Hicks noted in his reply brief, he did not file an appeal as to the dismissal of the MACP. And that was appropriate given that in this case, they had identified at least one insurer at the time the claim was filed over to the MACP. We went ahead and weighed in nonetheless with regard to the supplemental question.
Counsel, I want to just ask a quick question because again,
Sure.
I just want to kind of get to the root of it. And you guys are doing an excellent job, but you realize the challenges and problems with your argument, right? In terms of how it's going to be applicable in the real world to real people who are going through some pretty challenging times, and that you guys don't even agree as to how the plaintiff should proceed.
Well, Your Honor, I don't think the insurers and the MACP have to agree on everything. Obviously, there's a dispute that would be appropriate, I think, for this court to decide. But with regard to the one issue.
But in fairness, but I just have to say, but looking at this kind of from a common sense perspective, right? I mean, you guys have a lot more resources at your disposal than an individual plaintiff who's been in an accident or a serious accident, and you couldn't locate this person within the time parameters. And so now, the argument that a person who doesn't have the level of resources or ability that you do should have to do that is concerning.
Your Honor, in that statement that you just made, I think applies only to Trumbull. It does not apply to the MACP.
No, I understand. That's true. No, that's true. That's completely true. Right.
At the time this claim was filed with the MACP, an insurer had already been identified. And that's why it was not eligible for coverage under the MACP.
So
And
Ms. McAllister, can I just clarify? So it wasn't eligible to have an insurer assigned under the MACP because,
Correct.
as you say, an insurer had been identified, which was Trumbull, who wasn't paying because they said, despite them not being able to identify, that there's probably there should be somebody else out there. So Mr. Griffin literally didn't have anywhere to go, right? He couldn't even get an insurer assigned through MACP because of Trumbull, and Trumbull wasn't paying his claim because their contention that there was another insurer out there, despite their efforts hadn't uncovered that as well. You're saying that MACP couldn't assign an insurer because of the existence of Trumbull, correct?
Correct.
Okay.
And what I would further state, Justice Cavanagh, is, and this is where we differ from Ms. Kingler's position, is under our view, the plaintiff would have a remedy as against Trumbull in this particular situation. And we agree with the plaintiff's position that if someone has been identified in the order of priority, that when they're identified, they should pay. And we agree with the plaintiff with respect to that issue. But we don't agree that that triggers coverage under the MACP Act. And really, that's the reason that we weighed in with a brief in this matter, is we wanted to make sure that there was an understanding that there's a difference in the triggers between what would require a private insurer to respond and what requires the MACP to respond. Because one talks about who's in the order of priority. MACP doesn't have an obligation to respond if there's anybody there.
Right.
And that's the facts that we were faced with in this situation. So that's why we burdened the court with a brief in this case. And I poached a little bit of Ms. Kingler's time.
No, I appreciate it. I think that's
today.
an important point to make, to understand sort of who falls where and when. So I
Thank you,
appreciate
Your Honor. I appreciate the court's time today. Thank you.
Thank you both. Mr. Hicks, you have a little bit of time left.
Yeah, if I could just respond real quickly with regard to Ms. McAllister's argument on behalf of the MACP, I would just point out to the court that I did not seek leave to appeal from that decision. The court can simply not touch sub 3B of the Court of Appeals opinion. They don't need to address what the MACP's responsibilities are at this point. The statute is different for the MACP. There are different arguments to be made. I haven't gone into that. I don't know that I agree with her position because I don't think it's clear that the MACP has no duty to investigate, but that's really an issue for a different case. More importantly, with regard to Trumbull, what I see the court searching for clues of where is this duty to identify going to come from. And we've talked about the statute, but I've conceded in my brief that the plaintiff can't just go to their own insurer without doing anything at all. I mean, if there had been a VIN number on the police report, they have a duty to use diligence in pursuing the claim. The key here is if it's a due diligence standard in pursuing the claim, not necessarily proving the higher priority insurer, but due diligence in pursuing the claim, what does that mean? It means something very specific in the context of someone who paid a premium for protection. You can look to the contract and say, what is the insurer supposed to do for me? What am I supposed to do? What are my duties after the accident or loss? They're to notify, they're to cooperate, they're to get a PIP application in, and then the insurer needs to start acting. Trumbull's position seems to be, we really don't have to do anything. And I find that such a startling contrast, especially in a case like this. Trumbull is writes the AARP policies. So people that come through AARP want Hartford, they go to Trumbull. And what do they tell their insureds on? I was looking at their website the other day. Their website talks about Trumbull having their back. We're here to help you find the protection you need to feel confident. You'll need to find an insurance company that goes above and beyond for their customers. That didn't happen for Willie Griffin. Willie Griffin's here 5 years later, having paid a premium and having tried to get Trumbull and everybody else to pay, and yet he hasn't been paid. So the textual clues are out there, but the statute's very limited in what it says in this respect, but the policy is also relevant. And I think the common law is relevant, not just for the insured. I've acknowledged the insured has a duty to diligently pursue their legal claim, which we clearly did here. But the insurers also have a duty to investigate. And I put some citation in the supplemental brief about that duty. As long as you comply with what the policy says you have to do, they need to move forward. Trumbull did that and then just didn't tell us what happened and continued to make us, the insured, think that it was under investigation and didn't, as much as they want to say we should have filed a lawsuit, well, then they should have told them we've denied your benefits. Give them an opportunity to do that. Thank you very much.
Thank you, Mr. Hicks. Thank you all. The case will be submitted.
Thank you.